Question 1. Once an option contract has been agreed upon, the following parties can decide whether to exercise the option. A. Optionee. B. Optioner. C. Both A and BD broker. Correct answer is A. Optionee. Only the optionee, buyer, has the power to make a decision whether to exercise the option. The option agreement does not compel him to perform any action. Question 2. A deed would be void if A. Conveyed by a person in prison for robbery. B. Conveyed by a 17-year-old. C. Forged, in the possession of a purchaser for value. D. All of the above. Correct answer is C. Forged, in the possession of a purchaser for value. If a deed is executed by a minor, or if the grantor is mentally incompetent, a title transfer may be voidable, but is not automatically void as it is when a deed is forged. A prisoner can still convey a deed. Question 3. A subordination clause in a trust deed usually benefits the most. A. The truster. B. The beneficiary. C. The trustee. D. All the parties benefit equally. Correct answer is A. The truster. The borrower, truster, is the party who benefits the most from a subordination clause, because such a clause makes it easier to obtain another loan on their property. Question 4. If a real estate broker does not sign the purchase agreement in the appropriate place, then A. The seller does not have to pay the broker's commission. B. The broker will automatically have his license suspended. C. The agreement is voidable by either party. D. The agreement is still valid. Correct answer is D. The agreement is still valid. Such a failure to sign does not invalidate the purchase agreement or automatically result in the broker forfeiting his commission. Question 5. Information from a Chapter 7 bankruptcy are kept on credit records for A. 5 years. B. 7 years. C. 10 years. D. Forever. Correct answer is C. 10 years. Chapter 7 bankruptcy information remains on credit reports for 10 years. Question 6. The secondary mortgage market refers to A. Minor market. B. Market not as profitable as the primary market. C. Market to buy and sell existing mortgages that are pooled together. D. Market for training mortgage brokers. Correct answer is C. Market to buy and sell existing mortgages that are pooled together. The secondary mortgage market comprises lending institutions such as thrifts or mortgage bankers, private investors, and government credit agencies. They buy pools of existing loans from the primary markets. Question 7. The agency confirmation statement must be A. Signed prior to or at the time the parties enter into a contract. B. A separate document than the purchase agreement. C. Recorded. D. All of the above. Correct answer is A. Signed prior to or at the time the parties enter into a contract. This statement must be in writing, but need not be recorded. It is usually contained in the deposit receipt. Question 8. California's Fair Employment and Housing Act prohibits discrimination in all aspects of housing, except for housing specifically designed to accommodate A. Children. B. Senior citizens. C. Individuals with special needs. D. There are no exemptions from the Act. Correct answer is B. Senior citizens. Housing that meets the legal definition of housing for senior citizens is exempt from the familial status provisions of the Fair Employment and Housing Act. This means that such housing can legally discriminate against families with children. Question 9. Failing to perform as agreed upon under a contract is known as an A. Rescission. B. Novation. C. Breach. D. Redemption. Correct answer is C. Breach. Rescission refers to canceling a contract by mutual agreement of both parties. Novation involves replacing an existing contract with a new one that extinguishes the old obligations. Redemption is the act of buying back something that has been sold, often used in the context of mortgages or pawned goods. Breach is the failure of one or both parties to fulfill their obligations as outlined in a contract. Question 10. When a married couple, both persons under 18 years old, make a real estate contract, it is considered A. Valid, B. Void, C. Valid once at least one of the spouses turns 18, D. Non-enforceable. Correct answer is A. Valid. Married persons under the age of 18 are considered to be emancipated minors, who can contract as adults, and cannot disaffirm the contracts. Question 11. Nancy signs an apartment rental lease, which contain a covenant against assignment of the lease without consent of the lessor, Lenny the landlord. Nevertheless, Nancy assigns the lease to a friend without gaining Lenny's consent. The assignment is A. Void, B. Voidable, C. Illegal, D. Unlawful, punishable by a civil fine against Nancy, the would-be assigner. Lenny the landlord can, if he wishes, void that assignment, making it voidable. The lease itself can be cancelled at Lenny's discretion, making it voidable as well. Question 12. A solemn formal declaration by a person under the penalty of perjury that her statements are true is called an A. Affirmation, B. Affidavit, C. Declaration, D. Announcement. Correct answer is A. Affirmation. An affirmation is legally equivalent to an oath and may be substituted for it when a document requires an oath for its execution. Question 13. When a broker balances his trust account with his bank statement, it is called A. Restitution, B. Reconciliation, C. Balancing action, D. Clearance. Correct answer is B. Reconciliation. Restitution refers to the act of returning something to its rightful owner, often used in the context of resolving a breach of contract. Balancing action is a general term and doesn't specifically refer to the process of comparing a bank statement with account records. Clearance can involve settling financial obligations. It's not the specific term used for the process of balancing a trust account. Reconciling a trust account involves comparing the records maintained by the broker, checkbook register, with the official bank statement, to ensure all transactions are recorded accurately and there are no discrepancies. It's a crucial process for financial accountability and identifying potential errors. The BRE states that brokers should reconcile their cash record with bank statements on a monthly basis, keeping a separate record for each beneficiary transaction. Question 14. A broker's classified advertisement for a home he has a listing for includes the following information: 3-bedroom, 2-bathroom home, fireplace, patio, hot tub. Price is $350,000. Call 555-385-8764. This is an example of a display ad, B. blind ad, C. specific ad, D. California Realtors Association ad. Correct answer is B. blind ad. Failing to show that the name of the broker in an advertisement is called a blind ad, a violation of the real estate law. Question 15. Ms. Adams made a deposit on the purchase of a property. During the escrow, the seller learned of a highway rerouting which would greatly enhance the value of her property. She instructed the broker to return the deposit to the buyer. Ms. Adams refused to accept the deposit. Her most unlikely course of action would now be A. to pursue a lawsuit for specific performance from the seller, B. unilateral rescission, C. to file a claim for monetary damages, D. to accept a settlement. Correct answer is B. unilateral rescission. The other choices could provide Ms. Adams with some degree of remedy. To rescind unilaterally, give in, with nothing in return from the seller, would not gain her anything. Question 16. Which of these real estate transactions are exempt from the disclosure requirements in the California Civil Code that apply to conveyances of 1-4-unit dwellings? A. New homes sold in a subdivision where a public report is not required. B. Foreclosure sales. C. Transfers from one spouse to the other. D. All of the above. Correct answer is D. All of the above. New homes sold in a subdivision where a public report is not required. These transactions are exempt because a separate disclosure document, called a public report, is already provided by the developer. Foreclosure sales conducted under a power of sale provision in a deed of trust are exempt from disclosure requirements. Transfers between spouses are generally considered transfers within a marriage and are exempt from disclosure requirements. Other exemptions to certain disclosure requirements in the California Civil Code include transfers by a fiduciary in the administration of a decedent's estate and transfers resulting from failure to pay taxes. Question 17. During escrow, if the escrow instructions are in conflict with the deposit receipt, then the A. Escrow instructions are to be followed. B. Deposit receipt is to be followed. C. Seller can withdraw his offer. D. A new agreement between the parties must be executed. Correct answer is A. Escrow instructions are to be followed. The escrow instructions prevail over the deposit receipt contract. By signing the escrow agreement, the parties signify their reliance on that later document to state their transaction terms. Question 18. Principals face personal liability to creditors in A. Limited partnership. B. Partnership. C. Corporation. D. None of the above. Correct answer is B. Partnership. There is no personal liability for principals under limited partnerships or corporations. Question 19. The land description method that refers to the terms townships, sections, and ranges is A. Leaps and bounds method. B. Government survey method. C. Rectangular circumscribing method. D. Land analysis system. Correct answer is B. Government survey method. The government survey method specifies the location of property through its location in a particular township, section or range. Question 20. Which of the following is considered an advantage of FHA loans over conventional loans? A. FHA loans usually have a higher loan-to-value (LTV) ratio than conventional loans. B. FHA loans do not have to be paid back until at least 4 years after the loan is made. Circa FHA loans are more likely to have lower interest rates than conventional loans. D. Both A and C. Correct answer is D. Both A and C. Due to FHA loans' higher LTV, an FHA loan typically requires less cash put down at closing than with conventional loans. And, because FHA insurance lessens the lender's risk, they can charge lower interest rates. Question 21. A long-time general rule of contracts states that a party's acceptance of an offer is effective upon dispatch, even before the acceptance is actually received by the other party. This is called the A. Effective dispatch rule. B. Acceptance timing. C. Mailbox rule. D. None of the above. Correct answer is C. Mailbox rule. Acceptance timing is a general term and doesn't specifically refer to the rule regarding the effectiveness of acceptance upon dispatch. Effective dispatch rule phrase accurately describes the concept, but mailbox rule is the more widely recognized term. The mailbox rule is a legal principle that states that an acceptance of an offer is effective upon proper dispatch, even if it's delayed or never received by the offerer. The mailbox rule has been expanded to cover all technology by which commercial communication may reasonably be conducted, including telephone, email, and fax. Question 22. A property's selling price appears on a buyer's closing statement as A. Debit to the buyer. B. Credit to the seller. C. Debit to the seller. D. Credit for the buyer. Correct answer is A. Debit to the buyer. A buyer's closing statement features the selling price as a debit to the buyer, also showing as a credit to the seller on the seller's closing statement. Question 23. The following state differences between a trust deed and a mortgage, except A. The party that holds the security. B. The way title is conveyed. C. The number of parties. D. Both B and C. Correct answer is A. The party that holds the security. In both a trust deed and a mortgage alike, the security is held by the lender. As for differences, a trust deed has bare legal title conveyed to the trustee, while a mortgage has title maintained by the borrower. Also, a trust deed has 3 parties. A mortgage has 2. Question 24. The document used in a business sale that is akin to a grant deed in the sale of a home is called a bill of sale, b. deposit receipt, c. business transfer statement, d. bulk sales security agreement. Correct answer is a. bill of sale. A bill of sale transfers title to personal property as a grant deed conveys title to real property. Question 25. Upon an agent's disclosure of dual agency to the parties, if the parties consent to such an agency, it must a. be relayed to the state attorney's office, b. occur at least 30 days before the close of a transaction, c. disclosure of a dual agency is not required, d. be in writing. Correct answer is d. be in writing. If disclosure of a dual agency occurs, all principals must consent in writing. Question 26. The difference between the nominal rate of interest and the effective rate is a. The nominal interest rate is what is specified in the actual loan. The effective rate is what the borrower actually pays in interest. b. The nominal interest rate is specified in the actual loan. The effective rate is what borrowers are paying for a similar property. c. The nominal interest rate is the rate proposed by the borrower in negotiations with the lender. The effective rate is what the lender wants the borrower to pay. d. There is no difference between the nominal and effective rates. Correct answer is d. There is no difference between the nominal and effective rates. The nominal rate is the stated interest rate stated in the loan documentation. The effective rate takes compounding into account to determine the actual rate of interest that is paid. The difference between the nominal and effective rates increases with the number of compounding periods during the duration of the loan. The nominal rate of interest is what is specified in the note. The effective rate is the actual interest rate paid by the borrower. Question 27. An owner tells his listing agent that his home being sold, as is, has a leaky roof. The listing agent should a. tell the owner to paint over any water spots that indicate there is a leak, b. disclose the fact that the roof leaks to prospective purchasers, c. not disclose the fact that the roof leaks to prospective purchasers because it is not a material fact, d. disclose the fact that the roof leaks to prospective purchasers only if the purchasers ask specifically about any problems with the roof. Correct answer is b. disclose the fact that the roof leaks to prospective purchasers. The seller has a duty to disclose all known material defects, even with a house being sold, as is. Such a home sale means the seller must disclose to the buyer all known defects, but the seller will not pay for any repairs. A material fact is a fact that is important, significant or essential to a reasonable person in deciding whether or not to engage in a particular transaction. A leaky roof unquestionably qualifies as such a fact. Question 28. The right of a utility company to string power lines across privately owned land is an example of a. zoning ordinance, b. eminent domain, c. encumbrance, d. condemnation. Correct answer is c. encumbrance. Zoning ordinances regulate land use and development within a specific jurisdiction. They wouldn't directly address a utility company's right to install power lines. Eminent domain is the legal power of the government, or entities authorized by the government, to acquire private property for public use, often with just compensation to the owner. While eminent domain could be used to acquire land for power lines, it's not the term that describes the ongoing right of the utility company to use the land. Condemnation is the legal process by which the government exercises its power of eminent domain. Similar to eminent domain, it focuses on the acquisition of property, not the ongoing right to use it. Encumbrance is the most accurate answer. An encumbrance is a right or interest in a property that affects its ownership and limits what the owner can do with it. In this case, the utility company's right to have power lines on the property is an encumbrance on the private landowner's ownership. The landowner cannot completely exclude the utility company from the property for the purpose of maintaining the power lines. An easement in gross is an easement that is not created to benefit a particular parcel of land. but to benefit a specific user, in this case a power company. Easements in gross are in the larger category of encumbrances. Question 29. Broker Dolores sells a home listed by a broker from another brokerage. Her arrangement with the listing broker can be described as A. Selling broker, B. Third party, C. Co-agent, D. Principal. Correct answer is A. Selling broker. Normally, the listing broker splits commissions with the broker who procures the buyer for the property. A broker who works with the listing broker to procure a buyer is called the selling broker. The selling broker may be acting as the seller's sub-agent, an agent of the listing broker, or performing as the exclusive agent of the buyer. Bree Reference Book. Question 30. A licensee who misrepresents property to the buyer while acting as an agent of the seller is subject to A. Lawsuits, B. Discipline, C. Criminal penalties, D. All of the above. Correct answer is D. All of the above. Licensees making misrepresentations are subject to discipline, civil lawsuits, and/or criminal penalties. Question 31. While an estate for years automatically terminates when the agreed term expires, the lease can be ended before its expiration date with the tenant's consent. Such early termination is called a tender, B. Demise, C. Surrender, D. Reliction. Correct answer is C. Surrender. Estate for years is also called a term tenancy. The surrender must be in writing. Question 32. An open-end provision in a mortgage would benefit a borrower who wishes to A. Gain a discounted interest rate, B. Allow a subsequent purchaser to assume the loan, C. Borrow additional funds, D. Secure the loan with several different properties. Correct answer is C. Borrow additional funds. An open-end mortgage enables a borrower who has repaid a specific portion of the loan to borrow more money without having to reapply. Question 33. A verbal contract is called A. Invalid, B. Non-enforceable, C. Parole contract, D. Orally based agreement. Correct answer is C. Parole contract. Not all verbal contracts are invalid. They can be legally binding under certain circumstances. Some verbal contracts might be difficult to enforce due to lack of evidence. They aren't necessarily unenforceable altogether. Orally based agreement is a general description but doesn't have the specific legal term used for verbal contracts. Parole contract is a legal term that refers to a verbal or unwritten agreement. The word parole means verbal. It's important to note that enforceability of parole contracts can vary depending on the specific situation and jurisdiction. Some states have a statute of frauds that requires certain types of contracts to be in writing to be enforceable. Question 34. To create an escrow agreement, there needs to be an A. Oral agreement, B. Binding contract, C. Personal property, D. All of the above. Correct answer is D. All of the above. An escrow agreement is, in effect, a contract between the parties to move forward with a real estate transaction upon duties mutually performed by the parties. Question 35. Which of the following would include a protection clause? A. Option, B. Purchase agreement, C. Listing agreement, D. Agency agreement. Correct answer is C. Listing agreement. The protection clause, also called a safety clause, entitles the broker to a commission on a property sold after the listing term expires, provided the broker had negotiated with the same purchaser during the listing term. Question 36. Broker Brian had an exclusive listing on an apartment building, for which he procured a buyer. But after taking possession of the building, the buyer discovered the furnace did not heat the building properly, although broker Brian had informed the buyer, when the deposit receipt was made, that the furnace was in perfect working order and gave excellent heating. The buyer filed a lawsuit against the seller and broker Brian. At the trial, the seller testified he had informed Brian months before the sale that the furnace was broken down and needed to be replaced. The persons liable to the buyer for the non-working furnace. A. Both the broker and seller. B. Only the broker. C. Only the seller. D. Neither the broker or seller, since the buyer should have done an inspection of the property before the purchase and discovered the faulty furnace. Correct answer is A. Both the broker and seller. Broker Brian is liable because the broker has a duty to the buyer to disclose all material facts regarding the property and not make false statements. But the seller is also liable since the agent's principal is responsible for their agent's action performed within the scope of their authority. Question 37. Which of the following actions would not provide a defense for a homeowner against a mechanic's lien? A. Notice of completion. B. Untimely lien notice. C. Notice of succession. D. Notice of non-responsibility. Correct answer is C. Notice of succession. Note that a contractor must be licensed for the entire time work was performed in order to file a valid mechanic's lien, while a subcontractor working for a general contractor needs to give a preliminary 20-day notice to the homeowner for filing a lien. Question 38. The following are methods of involuntary alienation for the transfer of real property, except A. Adverse possession. B. Prescription. C. Devise. D. Either A or B. Correct answer is C. Devise. Adverse possession and prescription are legal terms used interchangeably to describe a situation where someone acquires ownership of real property through continuous, exclusive, and hostile possession for a specified period of time. This is a form of involuntary alienation because the rightful owner loses the property without their consent. Devise refers to the transfer of real property through a will. This is a voluntary alienation because the owner chooses to transfer ownership upon their death. Question 39. Which of the following is subject to control by a zoning ordinance? A. The type of structure that can be constructed on a lot. B. Property use. C. Building height. D. All of the above. Correct answer is D. All of the above. Zoning ordinances regulate building usage, along with size, shape and height. They also determine minimum distances between buildings and for property boundaries, including the setback and side yard requirements. Some of the purposes of the regulations are to control the proliferation of businesses which do not conform to community norms, to impact population density, and to help maintain open spaces and access to air and sunlight for ideal living conditions. Question 40. To ensure they are credited with a commission if the property sells after a listing terminates, brokers should try to insert this clause into the listing agreement. A. Safety clause. B. Contingency clause. C. Novation clause. D. None of the above. Correct answer is A. Safety clause. A safety clause, sometimes called a carryover clause, is often added to listings by brokers. The clause notes that a broker is still owed a commission for a certain time period after the listing has terminated on the condition that the property was purchased by a prospective purchaser, whom the broker procured during the listing period. Question 41. An improvement's economic life depends on the A. Repair policy of the owner. B. Improvement's age and condition. C. Improvement's use. D. All of the above. Correct answer is D. All of the above. An improvement's economic life depends on the owner's repair policy, the improvement's age and condition, and the use of the improvement. Question 42. In doing an audit of their lending activities, a lender discovered that most of its loans were seasoned loans. This meant that those loans A. Had their payment due dates extended. B. Were made throughout the different seasons of the year. C. Had a history of payments made on schedule. D. Had older loan recipients. Correct answer is C. Had a history of payments made on schedule. A seasoned loan refers to loans with a history of on-time payments. Question 43. Which of the following would be an estate in severalty? A. An apartment building with at least 7 units. B. A non-profit business taking title to real property. C. A corporation with 100 shareholders holding title to an estate. D. 7 or more people holding title as tenants in common. Correct answer is C. A corporation with 100 shareholders holding title to an estate. Sole ownership is an estate in severalty. Even though a corporation can be owned by multiple shareholders, it is viewed as a single legal person. It holds title in severalty. Question 44. In an open listing, a seller promises a commission to the broker if he finds a buyer, without a promise from the broker to find a buyer. This kind of contract is termed an A. Lee pendens, B. Unilateral contract, C. Open promise contract, D. Bilateral contract. Correct answer is B. Unilateral contract. An open listing, also called a non-exclusive listing, gives a number of brokers the right to sell a property. Unilateral contract is the most accurate description because it involves a promise by one party, the seller, without a return promise from the other party, the broker. The broker is only obligated to receive a commission if they find a buyer, but they are not under any obligation to actively search for one. Question 45. Oral agreements are A. Never valid, B. Also called parole agreements, C. Cannot amend written agreements, D. Both B and C. Correct answer is D. Both B and C. This parole evidence rule requires that when a written contract is in place between parties, the written contract must contain the entire agreement. Any amendments must be done in writing. This rule safeguards against any agreement that a party might make stating that the contract had been amended by a verbal agreement. Question 46. For appraisal purposes, the replacement cost approach is likelier to be applied to new buildings because A. Newer buildings are constructed of stronger materials, B. The way depreciation is estimated, C. Older buildings have less value than newer buildings, D. Changes in zoning laws. Correct answer is B. The way depreciation is estimated. The replacement cost approach relies on the calculation of depreciation to assess value, and with newer buildings, it is easier to assess depreciation. Question 47. A listing broker knows the property he is trying to sell has some structural damage, inadequate insulation, and it is overpriced by 10%. Nevertheless, he runs an ad that reads, "Charming, well-constructed two-bedroom home for sale, not a fixer-upper. Great price." The rules governing real estate ads have A. Not been violated, the broker is merely puffing, B. Been violated, because the broker knows that the price is actually not great, C. Violated, because the ad lies about material defects, D. Not been violated, because everyone knows ads aren't true. Correct answer is C. Violated, because the ad lies about material defects. Most of the ad can be seen as puffery, exaggerations reasonably to be expected of a seller as to the degree of quality of his product that no reasonable person takes literally, which is legal. But lying about a material defect like the property's construction qualifies as failure to disclose pertinent information, which goes against the truth in advertising laws in the State Business and Professions Code. Question 48. Older deeds and tax documents sometimes include the phrase, et ux, which means A. And wife, B. And others, C. Individually, D. Good luck. Correct answer is A. And wife. Et ux is short for the Latin phrase, et uxor, literally, and wife. Prior to women being allowed to own property in their own right or possess equal rights to property owned by their husband, a deed or tax record often referred to property as being owned by the husband, et ux. Question 49. Prior to burning trash on one's property, the should be notified A. Local Air District, B. The Federal Housing Agency, FHA, C. The Police Department, D. The Real Estate Commissioner. Correct answer is A. Local Air District. In California, the formal name for this agency is the Air Resources Board of the State Environmental Protection Agency. Question 50. To satisfy the statute of frauds, a listing agreement must A. Be in writing and signed by the seller and broker, B. Be in writing and signed by the seller, C. Be notarized, D. Does not have to be in writing, because it can be accomplished in less than a year. Correct answer is B. Be in writing and signed by the seller. According to the statute of frauds, a listing agreement must be in writing and signed by the seller. The broker's signature is not required, nor must it be notarized. Question 51. Which of these creates an agency relationship? A. Ratification, B. Estoppel, C. Express agreement, D. All of the above. Correct answer is D. All of the above. Ratification occurs when a principal, the person being represented, approves or accepts the actions of someone who acted on their behalf, the agent, even if there wasn't a formal agreement beforehand. By ratifying the actions, the principal creates a retroactive agency relationship. A legal concept can create an agency relationship by estoppel. If a principal's words or actions lead a third party to believe someone is their agent, and the third party relies on that belief in good faith, the principal might be estopped, prevented, from denying the agency relationship to avoid harm to the third party. Express agreement is the most straightforward way to establish an agency relationship. An express agreement clearly outlines the roles and responsibilities of both the principal and the agent. Question 52. The longest period of time during which a farm can be leased is A. 10 years, B. 25 years, C. 51 years, D. There is no limit on lease term duration for farms. Correct answer is C. 51 years. The maximum lease on farm property is 51 years. For urban property, it is 99 years. Question 53. The main goal of secured transaction laws is to A. To provide notice to future lenders, B. To ensure creditors take speedy possession of collateral, C. To regulate tax collection on real estate transactions, D. To educate debtors on their rights versus the lending industry. Correct answer is A. To provide notice to future lenders. Secured transactions rules function as a notice system for any subsequent investor that the first lender has pre-existing rights and a piece of collateral, which would take priority over theirs. Question 54. In 1925, a subdivision had a restriction enacted prohibiting property purchasers from ever reselling the property to members of the Jewish faith. Presently, the restrictions A. Enforceable, if a new purchaser agrees to follow it, B. Enforceable, if a majority of the current owners in the subdivision have agreed to follow it, C. Enforceable, but if an owner dies, the property can be left in a will to anyone, D. Unenforceable under any circumstances. Correct answer is D. Unenforceable under any circumstances. Restrictions, also known as CC&Rs or covenants, conditions and restrictions, based on race and religion are illegal. Question 55. Joe, who has not yet obtained his real estate license, is an employee of a real estate brokerage. While studying for the real estate exam, he can legally perform the following agency-related activities, except A. Search the MLS for new listings, B. Create a brochure for an open house, C. Keep client records organized, D. Show properties to prospective clients. Correct answer is D. Show properties to prospective clients. It violates BRE guidelines for an unlicensed individual to procure prospects or answer questions about a specific property that arise while showing a property. Question 56. The duties of a property manager include A. Creating an operating budget, B. Collecting rent, C. Conducting evictions, D. All of the above. Correct answer is D. All of the above. A property manager is a third party hired by the owner to handle the daily operations of a real estate investment. Question 57. For a lease to be properly recorded in the country recorder's office, the lessor must A. Have the lessee sign the lease, B. Acknowledge the lease, C. Notarize the lease. D. File the lease in triplicate. Correct answer is B. Acknowledge the lease. Acknowledgement refers to when the lessor confirms before a legal witness that his signature is genuine and voluntary. An unacknowledged deed may be valid but cannot be recorded. There is no requirement for the lessor to sign the document. Question 58. Mary wants to erect a 10-foot wall around her home to keep out intruders. Before construction starts, she should find out if this would violate A. Zoning laws, B. Restrictions, C. Both A and BD building codes. Correct answer is C. Both A and B. Both zoning ordinances and restrictions should be consulted regarding the acceptable height of the proposed wall. Question 59. Owner Oliver was given an offer by purchaser Paul to buy his condominium apartment. In the written offer, Paul specified that Oliver had a deadline of 2 weeks to consider it. 20 days later, after a competing offer fell through, Oliver accepted Paul's offer, which the listing broker communicated to Paul. The contract between the parties is A. Not binding, because the offer automatically expired after the 2-week deadline elapsed. B. Binding, because there has been a mutual meeting of minds. C. Binding, because Paul did not verbally revoke his offer. D. Not binding, because Oliver's late acceptance created a counter-offer that now must be accepted or rejected by Paul. Correct answer is A. Not binding, because the offer automatically expired after the 2-week deadline elapsed. Purchase contract offers typically spell out the time frame for acceptance, and an offer will terminate if not responded to within that period. Note, though, that a potential buyer may revoke his offer at any time. Question 60. Option contracts will be binding on the optioner if A. is mutually agreed on consideration between the parties. Pool cleaning services worth $100 are provided by the optionee to the optioner. B. The parties agree to consideration of $5,000 in cash, but it is never delivered to the optioner. C. The object of the contract is the construction of an illegal meth lab. D. None of the above. Correct answer is A. As mutually agreed on consideration between the parties, pool cleaning services worth $100 are provided by the optionee to the optioner. An option contract is a legal agreement between two parties that grants the buyer, optionee, the right, but not the obligation, to buy or sell a specific asset at a predetermined price within a set time frame. Consideration in an option contract may be a nominal amount or in the form of goods and services, but it must actually pass to the optioner for the option contract to be enforceable. An unlawful object will render an option, or any other kind of contract, void. Question 61. Regarding the relationship between a broker and her salesperson. The broker is an employer and the salesperson is an A. Independent contractor, B. Special agent, C. Employee, D. Either A or C. Correct answer is D. Either A or C. According to the real estate law, a salesperson is the broker's employee. But for tax purposes, the salesperson usually is considered an independent contractor. Question 62. The California real estate law is included in a section of the state's regulations code called the A. California Code of Regulations for Business, B. Business and Professions Code, C. Administrative Law Guide for Professionals, D. Ethical Conduct Code. Correct answer is B. Business and Professions Code. The Business and Professions Code sections 10,000 to 10,580 contain the Real Estate Law of California, aka the License Law. Along with the Real Estate Commissioner's regulations, the license law regulates the profession and protects the public from incompetent, immoral, or fraudulent real estate agents. Question 63. The top salesperson at a real estate agency informs his broker that he is leaving the agency and going to work for another broker. His current broker should A. Contact the other broker and threaten to report him to the authorities for stealing his salesperson. B. Return the license certificate to the salesperson. C. Not return the license certificate to the salesperson until he has made at least one more sale as compensation for the departure. D. Return the license certificate to the salesperson and immediately notify the real estate commissioner of his departure. Correct answer is D. Return the license certificate to the salesperson and immediately notify the real estate commissioner of his departure. A broker must notify the real estate commissioner if a salesperson transfers their license to a new broker. The broker must return the license certificate to the salesperson and notify the commissioner as soon as possible about the licensee's departure. The new broker must similarly notify the commissioner within 5 days of the salesperson's arrival. Question 64. Warhol promises to pay Wyeth $2,000 if Wyeth paints Warhol's house. Midway through the job, the house is destroyed in an earthquake. If Wyeth sues Warhol for payment, Wyeth will likely A. Win, according to the legal doctrine of restitution, B. Win, according to the legal doctrine of reliance, C. Lose, because it is not Warhol's fault that the house was destroyed, D. Lose, because the subject of the painting contract the house has been destroyed. Correct answer is A. Win, according to the legal doctrine of restitution. Usually, restitution is awarded in situations where one party has provided a benefit to another party under a contract, and that contract turns out to be unenforceable, as when the subject matter of the contract is destroyed. Restitution is used to pay the party providing the benefit for its reasonable value. Question 65. When can a broker, acting as the seller's agent, refuse to submit an offer to the seller from a potential buyer? A. If the broker's business associate has submitted an offer. B. If the owner is considering another offer. C. If the owner has provided the broker with specific instructions not to accept any further offers. D. Never, all offers must be presented. Correct answer is C. If the owner has provided the broker with specific instructions not to accept any further offers. A broker must submit any offer unless it is clearly frivolous, or the seller has expressly informed the broker not to submit any further offers. Question 66. A major difference between real property and personal property is A. Real property depreciates in value, personal property does not. B. Real property can be leased, personal property cannot. C. Real property is immovable, personal property can be moved. D. Real property can be paid for on an installment plan, personal property cannot. Correct answer is C. Real property is immovable, personal property can be moved. Real property, land, is immovable, while personal property, such as a car or jewelry, of course can move with its owner. Question 67. When two parties in a contract compose a new contract as a replacement, it is called an A. Reliction, B. Novation, C. Avulsion, D. Accession. Correct answer is B. Novation. Reliction, avulsion, and accession are all legal terms, describe property, but not refer to a contract. Reliction is the increase in land caused by the gradual recession or shrinkage of a body of water, such as a lake or sea, which gives the owner of the property more dry land. Avulsion occurs due to a sudden natural event, such as a powerful river, that erodes and abruptly detaches a portion of land from a coastal or riverfront property. The detached land may belong to the owner of the avulsed property if it moves to an adjacent location. However, if the avulsed land moves to a more distant location, its ownership may need to be determined according to law. Accession is when personal property permanently attaches to another item, raising its value. Novation is a legal term that refers to the creation of a new contract that extinguishes, overrides, a previous contract between the same parties. Both parties involved agree to replace the original contract with the new one, effectively terminating the old obligations and replacing them with the new terms. Novation can either be the substitution of a new party into an existing contract, or the substitution of a new obligation for an existing one. Question 68. When an agent is showing several properties to a potential client, she should do all of the following, except A. Choose homes that meet the client's needs, B. Provide scorecards for the client to rate the properties. C. Start the tour in the most impressive room in the house. D. Use technical jargon throughout the tour. Correct answer is D. Use technical jargon throughout the tour. An agent should try to educate potential purchasers, but not overdo it. Technical jargon in any profession can create confusion and misunderstanding for those not in the know. Question 69. Ruby owns a tire store. In consideration for an option to buy a parcel of land from Betsy, Ruby offered Betsy 4 free tires. Assuming that the other elements of a valid option are present, the option is A. Invalid. Tires cannot serve as consideration. B. Valid, if the value of the tires exceeds $400. C. Valid, if Betsy accepts the tires as consideration. D. Valid, if Betsy owns a car. Correct answer is C. Valid, if Betsy accepts the tires as consideration. Consideration can be in the form of goods, with no minimum value requirement. As long as the optionee accepts the consideration as having some value, then the offer is supported by consideration and legal. Question 70. To hold real property as a tenant in common, parties must A. Have undivided interests. B. Be married to each other. C. Have equal interests. D. Inhabit the property. Correct answer is A. Have undivided interests. For 2 or more persons to hold title to the same property as tenants in common, they are required to hold an undivided interest. An undivided interest means not specifying the interests of each party by percentage or description of a portion of the real estate, property. You cannot designate which 1/3 of the property you own. Question 71. Surveys show that classified ads are most commonly used by people as their primary method for finding real estate properties. A. In their 50s. B. In their 30-40s. C. In their 20s. D. In all age groups. Correct answer is A. In their 50s. Those under 50 are more likely to rely primarily on the internet in search of properties. Question 72. The Real Estate Settlement Procedures Act, RESPA, designed to protect consumers from abuses by loan servicers, applies to all of the following, except A. Requiring lenders to provide loan applicants with good faith estimates of closing costs within 3 days of their application. B. Compelling closing agents make a uniform settlement statement available to the buyer at least 1 day before closing. C. Loan transactions being used for temporary financing, such as a bridge loan. D. A borrower being pressured to make excessive contributions to an escrow account designed to cover recurring costs like taxes and insurance. Correct answer is C. Loan transactions being used for temporary financing, such as a bridge loan. Bridge loans are typically short-term financing solutions used to gap the period between selling one property and buying another. Since they are short-term and not intended for long-term occupancy, RESPA's regulations regarding disclosures and settlements are often not applicable. Also within 3 days of receiving a loan application, RESPA requires lenders to provide applicants with a mortgage servicing disclosure statement revealing whether the lender intends to service the loan or transfer it to a different servicer. Question 73. The parole evidence rule states that, in most situations, A. Oral agreements can always be used to modify written agreements. B. Written agreements take priority over oral agreements. C. An oral agreement is a quasi-contract. D. Oral agreements are always invalid. Correct answer is B. Written agreements take priority over oral agreements. Written contracts have precedence over oral contracts, while oral amendments to written agreements will generally not be enforceable. Question 74. The likeliest person to incur a prepayment penalty in a real estate deal is the A. Seller. B. Borrower. C. Lender. D. Owner. Correct answer is A. Seller. The alienation clause is a prepayment penalty that makes the seller responsible for repaying the entire loan amount. The alienation clause is also referred to as due on sale clause. This provision gives the lender the right to accelerate the loan. Question 75. The longest length of time a lease will be valid for is A. 51 years for a farm property, B. 99 years for an urban property, C. 50 years for either farm or urban properties, D. Both A and B. Correct answer is D. Both A and B. Leases for oil, mineral or gas production also cannot exceed 99 years. Question 76. When an asking price is initially based on a listing contract, it will probably A. Have a high-end market value, B. Have a low-end market value, C. Have a mid-range market value, D. Not reflect the sales of other properties in the same neighborhood. Correct answer is A. Have a high-end market value. The owner and broker will likely try to sell at the maximum price. Only if the asking price proves a deterrent to a sale would they bring down the cost to reflect neighborhood price values. Question 77. Land includes the following rights: A. Water rights, B. Mineral rights, C. Surface rights, D. All of the above. Correct answer is D. All of the above. The term land refers to the Earth's surface, the material that extends downward to the planet's center. Land also includes the rights to the airspace above it. Question 78. If an appraiser increases the capitalization rate on income property, that means the appraiser is predicting A. Higher gross income, B. Higher return, C. Higher degree of risk, D. Higher net income. Correct answer is C. Higher degree of risk. Capitalization rate, cap rate, is a ratio used in real estate valuation to estimate the potential return on an investment property. It's calculated by dividing the property's net operating income, NOI, by its current market value. When an appraiser increases the cap rate, it signifies a decrease in the perceived value of the property relative to its income potential. This can be due to several factors, including greater than increased risk associated with the property, e.g., vacancy rates, potential for lower future income, greater than higher operating expenses anticipated for the property, greater than lower overall market demand for similar properties. Therefore, a higher cap rate suggests a higher degree of risk associated with the property, leading to a lower predicted return on investment. Question 79. The most efficient approach for appraising a library is the A. Comparables method, B. Market data method, C. Reproduction cost method, D. Income capitalization method. Correct answer is C. Reproduction cost method. Libraries are rarely, if ever, sold, so there would be no comparables for the comparison approach to use. Similarly, with no income from a sale, the capitalization of net income will not work. Rather, the reproduction cost method, with its emphasis on the cost of replacing the library, is most appropriate here. Question 80. To be enforceable, a buyer representation agreement does not have to A. Be written, B. Include a legal description of the property, C. Be signed by the buyer, D. Include a termination date. Correct answer is B. Include a legal description of the property. A buyer representation agreement is between a buyer and a broker, through which a buyer looking to purchase a property employs a broker to find a suitable one. Per the statute of frauds, to be enforceable, the buyer representation agreement should be in writing and signed by the buyer. According to the real estate law, the agreement should mention a termination period. Question 81. Even if a loan application is rejected due to information included in a credit report, the borrower does not have the right to the following to be A. Notified of the reason why his loan was denied, B. Informed of all information about him, including the sources, from the records of the credit reporting agency, C. Have a second chance, within 1 month, to apply for the loan, D. Informed of all creditors in the last 6 months who have received a copy of his credit report. Correct answer is C. Have a second chance, within 1 month, to apply for the loan. Even if a loan application is denied based on credit report information, the borrower has certain rights protected by the Fair Credit Reporting Act, FCRA. They must be informed of the reason for the denial and can access a free copy of their credit report annually to see the information used in the decision. Borrowers can also learn who viewed their credit report in the past year, but not the specific creditors who received a copy. However, the FCRA does not guarantee a second chance to apply for the loan within a specific time frame. The lender may choose to reconsider, but they are not obligated to. Question 82. Someone who can execute a valid will is said to have A. Willfulness, B. Pledging power, C. A promissory note, D. Testamentary capacity. Correct answer is D. Testamentary capacity. A different word for will is testament. A person with the capacity to make a will has testamentary capacity. Question 83. A buyer may rescind a purchase contract for a property for after entering into the contract. A. 1 day, B. 3 days, C. 10 days, D. There is no right to rescind a purchase contract. Correct answer is B. 3 days. The statutory right to rescind contracts runs for a 3-day period, beginning from the date the contract is agreed to. Question 84. Randy has a mood disorder which can cause him to act severely irrational. During one of his manic episodes, Randy is convinced by a telemarketer to enter into a contract for a timeshare property. The contract is A. Void, B. Voidable, C. Valid, D. Modifiable by a counter-offer. Correct answer is B. Voidable. If Randy can demonstrate that he was temporarily incompetent due to his mental disorder when he made the contract, then it is voidable, and he has the option to require that the timeshare agreement be executed or to disaffirm it. A timeshare is a shared ownership model of vacation real estate, in which multiple buyers own the rights to use the same property at different times in a year. Question 85. An effective listing interview between an agent and prospective client should A. Be standardized to cover every kind of property, B. Focus mainly on the licensee's selling achievements, C. Be specifically tailored for each particular property, D. Focus mainly on the licensee's career achievements. Correct answer is C. Be specifically tailored for each particular property. At the listing appointment, while the agent should try to demonstrate the qualities distinguishing her from other agents, her emphasis should be on the specifics of the property and how best to present it. Question 86. A property estate is granted by John to Bob for the life of Ruby. The three go fishing and Bob dies in a hurricane, while John and Ruby survive. The estate A. reverts back to John, the original owner, B. no longer exists, C. has its ownership decided by a judge, D. vests in Bob's heirs. Correct answer is D. vests in Bob's heirs. For as long as Ruby is alive, the life estate belongs to Bob, the life tenant or Bob's heirs in the event of his death. Question 87. The following statements regarding a broker's trust account are true, except A. Trust funds received by a broker must be deposited in a trust account. B. Trust funds cannot be deposited into an interest-bearing account. C. A minimum balance is not mandatory. D. Trust funds cannot be deposited into an account also containing rental income and security deposits from broker-owned properties. Correct answer is A. Trust funds received by a broker must be deposited in a trust account. Trust fund amounts do not have to be deposited into a trust account. They may also be paid directly to the seller or deposited into escrow or another neutral account. The buyer and seller together may also provide alternate instructions for deposit. Question 88. Before a real estate license is renewed, it is required to complete hours of approved courses within a 4-year period. A. 15, B. 25, C. 45, D. 100. Correct answer is C. 45. The California Bureau of Real Estate requires real estate licensees to complete 45 hours of continuing education every 4 years in order to renew their license. The renewal application cannot be submitted to the BRI more than 90 days before the expiration of the license. Question 89. A potential real estate buyer without a real estate license can do the following. A. Negotiate directly with a seller. B. Make a secret profit. C. Deposit funds with an escrow agent. D. All of the above. Correct answer is D. All of the above. There is no law against a buyer speaking directly with a seller, or making a deposit on a property with an escrow agent. Also, a non-licensee can buy a property and then resell it without revealing his profit to the first seller, a secret profit, while a real estate licensee cannot. Question 90. A would-be home buyer's loan application was turned down due to a negative credit report. If the applicant's request to see the credit report is denied, the applicant can A. Sue for actual damages. B. Sue for attorney fees and court fees. C. Both A and B. D. Sue for punitive damages up to $100,000. Correct answer is C. Both A and B. State law mandates that credit reporting agencies must share an applicant's credit report if requested by the applicant. Agencies that fail to do so are liable for actual damages, punitive damages up to $5,000 and legal fees. Question 91. Gordy is at the local ice skating rink when some other boys begin a hockey game. Gordy, a big hockey fan, asks to play and is put on one of the teams. During the game while going for the puck, Mario checks Gordy hard into the side of the arena, breaking Gordy's arm and a few of his ribs. If Gordy sues Mario for battery, Mario will probably A. Lose, because Mario hit Gordy on purpose. B. Win, because Gordy joined the game voluntarily and with knowledge of its rules. C. Lose, because Gordy suffered multiple injuries. D. Win, because Gordy had a duty to avoid being hit. Correct answer is B. Win, because Gordy joined the game voluntarily and with knowledge of its rules. Gordy joined the game on his own accord, meaning he consented to playing the game with all its rules, one of which includes checking. Although Mario hit Gordy intentionally, this contact was consented to by Gordy when he asked to participate and joined the game. Question 92. Which actions by a real estate broker would provide grounds for disciplinary action against him? A. The broker did not include a definite termination date in a listing agreement. B. The broker did not include a broker safety clause in a listing agreement. C. Despite his best efforts, the broker was unable to find a buyer for a property he listed. D. The licensee disclosed to the seller in a timely fashion that a potential buyer once worked for the licensee. Correct answer is A. The broker did not include a definite termination date in a listing agreement. If a real estate broker offers a listing agreement that does not have an expiration date, in California, and in most other states, the broker's license can be suspended or revoked. Question 93. Which corner is usually considered the most advantageous location for a retail establishment? A. Northeast. B. Southeast. C. Northwest. D. Southwest. Correct answer is D. Southwest. The southwest corner is generally the most desirable positioning for a business that partially relies on foot traffic, because it offers the most shade to pedestrians. Question 94. Which of the following are not township coordinate survey systems? A. Humboldt baseline and meridian. B. Mount Diablo baseline and meridian. C. San Andreas fault baseline and meridian. D. San Bernardino baseline and meridian. Correct answer is C. San Andreas fault baseline and meridian. This is not a real township and baseline coordinate system. The San Andreas fault is a geological feature, not a reference point for land surveys. The survey systems use imaginary lines to set land descriptions, baselines that go east-west and meridians running north-south. Question 95. When an appraiser looks at income from a neighborhood's rental properties for its highest and best use, the income being analyzed is A. Economic rent. B. Maximum rent. C. Developed rent, with broker's commission subtracted. D. High rent. Correct answer is A. Economic rent. The rent being charged for similar apartments in the neighborhood is economic rent. If the apartment leases are long-term, the appraiser will use contract rent. Question 96. By law, federal deposit insurance must cover A. Bank. B. Federally chartered savings and loans. C. State chartered savings and loans. D. Both A and B. A. Bank. B. Federally chartered savings and loans. Correct answer is D. Both A and B. Most banks have their deposits insured by the FDIC. While federally chartered savings and loans come with deposit insurance from the FSLIC. It is not mandatory for state-chartered S&Ls to have such insurance, but most do anyway. Question 97. A property owner and broker sign an agreement for the owner to pay the broker a commission. If the broker uses due diligence to procure a ready, willing and able buyer, this agreement is an example of an A. Unilateral executory contract. B. Bilateral executory contract. C. Bilateral executed contract. D. No contract has been formed. Correct answer is B. Bilateral executory contract. Bilateral means both parties are bound by the contract terms to perform an act or acts. Executory means the contract terms have not yet been performed. Executed would mean the terms had been performed. Question 98. Which of the following would be considered incurable functional obsolescence in a department store? A. Window displays that are uninviting. B. Bad lighting. C. Cheap building materials. D. Discordant music playing in the elevator. Correct answer is C. Cheap building materials. Functional obsolescence is incurable where the cost to cure the obsolescence is greater than the amount of the obsolescence, while the other problems could be fixed at a less than crushing expense. Rebuilding the entire store would cost more than the problems being caused by the poor materials. Question 99. In a graduated payment mortgage, GPM, partially deferred payments on the principal loan amount are A. Made at the start of the term with the payments decreasing as the loan matures. B. Made at the start of the term with the payment increasing as the loan matures. C. Deferred until the end of the term. D. Dependent on the rise and fall of the prime rate. Correct answer is B. Made at the start of the term with the payment increasing as the loan matures. Also known as a flexible rate mortgage, this loan is appropriate for buyers who are expecting to earn more in the future when then can make larger payments. Question 100. The conforming loan limit for California counties is A. $33,000, B. $100,000, C. $417,000, D. There are no limits on conforming loans. Correct answer is C. $417,000. Fannie Mae and Freddie Mac are restricted by law to purchasing single-family mortgages with origination balances below a specific amount, known as the conforming loan limit. Loans above this limit are known as jumbo loans. Question 101. Someone who would be judged to be incompetent may still be bound by signing a contract for A. Real property with a value below $1,000. B. Anything besides real estate. C. Real property of any value. D. Necessaries. Correct answer is D. Necessaries. Necessaries refers to essential goods and services that a person needs to survive, such as food, shelter, clothing, and medical care. The law recognizes that even someone who is incompetent has a basic right to obtain these necessities. Therefore, even if a person is judged incompetent, they might still be bound by a contract for necessities. If the following conditions are met: greater than the contract was for essential goods or services. Greater than the price charged was fair and reasonable. Greater than the seller was unaware of the person's incompetence. In such cases, the court might reason that the contract is necessary to protect the well-being of the incompetent person. Question 102. The ways in which the government acquires title to real estate include A. Escheat, B. Municipal acquisition, C. Eminent domain, D. Both A and C. Correct answer is D. Both A and C. Escheat describes what occurs when a person dies without a will, intestate, with no heirs to take ownership of his property. It is then acquired by the government. Eminent domain, the more frequently used method, refers to the right of the government to take private property for public use. Usually, property acquired by eminent domain is used for needed government buildings, public utilities, or highways. Question 103. The minimum notice period an owner must give his apartment building tenants when the building will be converted to a condominium is A. 90 days, B. 180 days, C. 6 months, D. There is no minimum notice requirement for such condo conversions. Correct answer is B. 180 days. The owner-converter also has to provide each tenant with the opportunity to buy their apartment when the conversion is finished. Question 104. A wooden roof's highest point is called A. Ridge board, B. Top notch, C. Rafter, D. Hoist. Correct answer is A. Ridge board. Rafters are the sloping beams that support the structure of the roof. They run diagonally from the eaves, the lower edge, to the peak. Top notch refer to the V-shaped joint at the peak of a roof where two opposing rafters meet. But it's not the highest point itself. A hoist is a lifting device and wouldn't be part of the permanent structure of the roof. The ridge board is the horizontal board located at the highest point of the roof. It runs along the peak, where the opposing top ends of the rafters meet and are secured. Question 105. Literal rights concern properties adjoining the following: A. Ocean, B. River, C. Lake, D. Both A and C. Correct answer is D. Both A and C. Literal rights are usually concerned with the use and enjoyment of the shore of oceans and lakes. Riparian rights relates to rivers and streams. Question 106. No two pieces of property are exactly alike. Which is one of the reasons the courts devised the legal concept of A. Estoppel, B. Easements, C. Specific performance, D. Lee pendens. Correct answer is C. Specific performance. The fact that one piece of land cannot be substituted for another, which also makes monetary damages impractical, is the primary basis for courts to command specific performance, which compels a party to execute a contract according to the agreed-upon terms. Specific performance grants the plaintiff what he actually bargained for in the contract. Question 107. A voidable contract remains in force until it is A. Modified, B. Conformed, C. Rescinded, D. Notarized. Correct answer is C. Rescinded. If legal action to withdraw from the contract is not taken within a stipulated time, the court may declare the contract as ratified. In cases where the injured party desires to continue with the contract, he may ratify it. Question 108. With a property with more than one mortgage on it, the one with the highest priority usually A. has the highest interest rate, B. has the lowest unpaid balance, C. has the highest unpaid balance, D. was recorded first. Correct answer is D. was recorded first. Generally, the priority of a lien is determined by its recording date. Although some liens, such as property tax liens, have automatic superiority over essentially all prior liens. Question 109. A seller's broker can be liable to the buyer when A. the listing agreement is of the exclusive right to sell type, B. acting beyond the scope of their employment contract, C. acting as an attorney in fact for the seller, D. either A or C. Correct answer is B. acting beyond the scope of their employment contract. A broker's contract normally makes them the agent of the seller. but by performing actions not covered under the terms of their contract. A broker would then be acting as an agent of the other party, the buyer. Question 110. On the sale of a business, which of the following items would incur sales tax? A. Furniture. B. Goodwill. C. Fixtures. D. Both A and C. Correct answer is D. Both A and C. Sales tax is collected on the transfer of furniture and fixtures. Goodwill is not taxable. Question 111. A major advantage of an investment in real estate over the stock market is A. Appreciation. B. Depreciation. C. Interest rate decline. D. Like-kind exchanges. Correct answer is B. Depreciation. An investor can benefit from the depreciation deduction offered by real estate, not available from stocks or bonds. Question 112. Once a listing agreement is signed, a fiduciary relationship exists between the A. Broker and seller. B. Broker and buyer. C. Broker, buyer and seller. D. No fiduciary relationship exists. Correct answer is A. Broker and seller. The broker and seller are the two parties to a listing agreement. The listing creates an agency relationship, which places the agent, the broker, in a position of trust, owing a fiduciary duty to the principal, the seller. Question 113. A provision in a security instrument stating that the instrument will have a lower lien priority than another mortgage or deed of trust is called A. Acceleration clause. B. Secondary lien position clause. C. Subordination clause. D. Priority positioning clause. Correct answer is C. Subordination clause. This clause makes it possible for a later recorded security instrument to assume a higher priority lien position. Usually, subordination clauses are used in mortgages securing purchase loans for unimproved land, when the borrower is planning to obtain a construction loan later from a lender who will demand the superior lien priority. Question 114. A salesperson must have with a broker that the salesperson that covers supervision of licensed activities, duties and compensation. A. Basic understanding. B. Signed, written agreement. C. Mutual stake in ownership. D. None of the above. Correct answer is B. Signed, written agreement. If a supervising broker dies, goes out of business, or has her license suspended or revoked, all of her listings will usually be terminated. Question 115. A deed is required to A. Be signed by a legally competent grantee. B. Include a legal description of the property being conveyed. C. Be signed by a legally competent grantor. D. Include the history of prior ownership of the property dating back at least 25 years. Correct answer is C. Be signed by a legally competent grantor. Neither a grantee's signature or legal description is mandatory for deeds. Neither is a record of past ownership. Question 116. A tenant with a lease to reside in an apartment building asks the landlord to repair the furnace that provides heat for all the units in the building. The landlord ignores the tenant's repeated requests. It is winter time and very cold in the building. In reaction, the tenant decides to stop paying his monthly rent until the landlord does the repairs. The tenant is A. Legally in the right. B. Legally in the wrong. C. Authorized to check into a hotel and have the landlord pay the bill. D. None of the above. Correct answer is A. Legally in the right. According to the Bree reference book, if the landlord does not honor a lease's implied warranty of habitability, such as providing heat for a building in the winter, the tenant can be considered constructively evicted. That means he may remain in possession and halt rental payments according to how much his use and enjoyment of the premises has been impaired. Question 117. Which of these expenses would not be included in the uniform settlement statement form provided to the parties after a RESPA covered transaction closes? A. Appraisal fee. B. Finder's fees paid to a lender by a broker. C. Title insurance fee. D. Pest inspection cost. Correct answer is B. Finder's fees paid to a lender by a broker. The Real Estate Settlement Procedures Act, RESPA, is designed to ensure transparency and prevent borrowers from being unfairly burdened by excessive closing costs. Finder's fees are an internal business arrangement between the lender and the broker, not a cost directly charged to the borrower. Finder's fees are illegal under RESPA. Question 118. Complete title to a property can be transferred with A. Trust deed. B. Grant deed. C. Both A and B. D. Neither A or B. Correct answer is B. Grant deed. A grantor uses a grant deed to transfer title to a grantee. A trust deed is a security device in which legal title in real property is transferred to a trustee, who holds it as security for a loan between a borrower and lender. Equitable title remains with the borrower. Question 119. The amount of annual property taxes paid by a homeowner is determined by A. Collectively assessing the land and improvements, then multiplying by the tax rate. B. Separately assessing the land and improvements, then multiplying the total by the tax rate. C. Separately assessing the land and improvements, then multiplying by different tax rates. D. Any of the above. Correct answer is B. Separately assessing the land and improvements, then multiplying the total by the tax rate. Land and improvements are valued separately, although the tax rate is the same. Question 120. A. N. is a lien. A. Implied promise. B. Easement. C. Homestead. D. Attachment. Correct answer is D. Attachment. A lien must have a monetary value, so only an attachment qualifies as correct. Question 121. As a real estate term, devise means A. Testamentary gift of real property. B. Plan a will. C. Testator's signature. D. Notarization of a will. Correct answer is A. Testamentary gift of real property. In common usage, devise refers to making a plan. In traditional real estate language, devise means a conveyance of real property in someone's will. Question 122. The elements are required for a contract to be valid, except A. Lawful objective. B. Mutual assent. C. Consideration. D. Recording at county records office. Correct answer is D. Recording at county records office. The purpose of the contract cannot violate the law or public policy. Lawful objective. Both parties must agree to the terms of the contract. Mutual assent. Each party must offer something of value, money, goods, services, or a promise, in exchange for the other party's performance. Consideration. Recording at the county recorder's office is not required for a contract to be valid. Recording serves a different purpose. Question 123. The following are examples of illegal practices by a real estate licensee, except A. Blockbusting. B. Redlining. C. Steering. D. Panic selling. Correct answer is B. Redlining. All four describe illegal and unethical acts. Redlining, the practice of discrimination based on the racial makeup or character of a person's neighborhood, is committed by financial institutions, not individual licensees. Blockbusting involves encouraging residents of a neighborhood to sell their properties at low prices, by playing on their fears of a decline in property values due to a racial or ethnic minority influx. Steering is a licensee directing potential buyers or renters to certain neighborhoods, based on their race, ethnicity, or other discriminatory factors. Panic selling, while not strictly illegal itself, pressuring a seller to accept a lower price due to unfounded fears or creating a sense of urgency, can be unethical and manipulative. Redlining involves denying or limiting financial services, mortgages, insurance, to residents of specific neighborhoods, often based on racial or ethnic makeup. Question 124. An executor of an estate is A. Appointed by the Real Estate Commissioner. B. Not authorized to make any decisions regarding the estate without the prior approval of a probate judge. C. Named in the will of the deceased. D. The eldest heir of the deceased. Correct answer is C. Named in the will of the deceased. The duties of an executor include making sure that debts and creditors of the deceased are paid, while any remaining money or property is distributed according to their expressed wishes. Question 125. An exclusive listing is an agreement through which the seller promises to pay a commission regardless of who finds a buyer, and the broker promises to make a sincere effort to find a buyer. In other words, a promise is made in exchange for a promise. This kind of contract is called A. Unilateral contract. B. Bilateral contract. C. Seller's contract. D. Buyer's contract. Correct answer is B. Bilateral contract. A bilateral contract involves mutual promises between two parties. In an exclusive listing, the seller promises to pay a commission, and the broker promises to make a sincere effort to find a buyer. Both parties are making promises in exchange for the other's promise. Question 126. Prepaid rental listing agents are required to do the following, except A. Return the client fee if no referrals are submitted within 5 days of the agreement's execution. B. Provide a contract and receipt for every potential tenant, promising the return of their fee if certain circumstances are met. C. Submit an account statement to the Real Estate Commissioner on a quarterly basis. D. Refund any funds over $25 if a rental is not procured. Correct answer is C. Submit an account statement to the Real Estate Commissioner on a quarterly basis. A prepaid rental listing agent is required to keep records available for the Real Estate Commissioner's inspection at any time. Agents should be prepared to submit quarterly reports to principals regarding how the funds are used. Question 127. Which of the following is not an essential element of value? A. Utility. B. Expectation. C. Demand. D. Scarcity. Correct answer is B. Expectation. To have value, a product must have the following 4 attributes, known as the elements of value: utility, scarcity, demand, and transferability. Question 128. For the purposes of income tax, an owner's investment in a property is called the A. Taxing benchmark. B. Basis. C. Standard. D. Undivided interest. Correct answer is B. Basis. When an asset is sold by a taxpayer, the basis is the maximum amount received for the asset without realizing a gain. The basis is used to calculate taxable gains and losses. Question 129. A. N. is a voluntary conveyance of the right to maintain land in its natural state. A. Conservation easement. B. Solar easement. C. Easement in gross. D. Zoning variance. Correct answer is A. Conservation easement. Conservation easement is indicated as the right answer based on the question's reference to keeping land in its natural state. Solar easement grants the right to use a specific property for solar energy collection, not necessarily preserving the natural state. Easement in gross is a broader legal term referring to a non-possessory right to use another's property. A zoning variance is a permission granted by a local authority to deviate from existing zoning regulations for a particular property. A conservation easement is a legal agreement between a landowner and a qualified land trust or government agency. The landowner voluntarily agrees to restrict development or use of the land in a way that protects its natural heritage, scenic beauty, or ecological value. Through a conservation easement, the landowner retains ownership of the property, but gives up the right to develop it in certain ways. Conservation easements are a valuable tool for land preservation and can offer tax benefits to the landowner. Question 130. A person operating a business on a property he is leasing holds A. Leasehold estate. B. Freehold estate. C. Less than freehold estate. D. both A and C. Correct answer is D, both A and C. Also known as a leasehold estate. A less than freehold estate is held by one who rents or leases property. Question 131. The following are sources of demand for mortgage funds, except A. Home construction, B. New business, C. Federal home loan banks, D. Land development. Correct answer is C. Federal home loan banks. Federal home loan banks represent the largest collective provider of home mortgages in the United States. The other answers all are sources of demand for loans. Question 132. When a sublease is made, the following occurs. A. Primary responsibility for paying the rent remains with the original tenant, sublessor. B. Primary responsibility for paying the rent is transferred to the new tenant, sublessee. C. The original lease is terminated by the sublease. D. Possession of the property is transferred to the lessor, but for less than the full term. Correct answer is A. Primary responsibility for paying the rent remains with the original tenant, sublessor. In a sublease, liability for paying the rent remains with the original tenant, sublessor. Possession of the leasehold is transferred to a new party, sublessee, for the remainder of the lease term. The making of a new lease contract is called a novation, terminating the liability of the original tenant. Question 133. In the wake of the widespread savings and loan failures of the 1980s, a law abolished the Federal Home Loan Bank Board and created the Office of Thrift Supervision to supervise savings institutions. The new law was called A. The Savings and Loan Rescue Act, SLRA, B. The Thrift Authority, C. The Financial Institutions Reform, Recovery, and Enforcement Act of 1989, FIREA. D. United States Savings Bank Central Command. Correct answer is C. The Financial Institutions Reform, Recovery, and Enforcement Act of 1989, FIREA. The act was utilized after the subprime mortgage crisis to make it easier to prosecute banks which misrepresent the quality of their loan portfolio. Question 134. The following written instruments are contracts, except A. Mortgage, B. Exclusive authorization to sell listing, C. Escrow instructions, D. Quitclaim deed. Correct answer is D. Quitclaim deed. A quitclaim deed, as well as any other type of deed, is not a contract. Question 135. Acting on behalf of more than one party involved in a transaction is A. Illegal, B. Permissible, if properly disclosed and agreed to by the parties, C. Unethical, D. Renders the transaction voidable. Correct answer is B. Permissible, if properly disclosed and agreed to by the parties. Note that failing to disclose such a dual agency violates the real estate law. Question 136. Which of the following would not be paid by escrow disbursements? A. Hazard insurance, B. Real estate taxes, C. Mortgage insurance, D. Personal taxes. Correct answer is D. Personal taxes. Personal taxes are never paid from escrow accounts. Question 137. Four persons owned equal interests in a large vacant lot as tenants in common. One of the co-tenants decided to lease the property to a developer planning to build a high-rise apartment building. The lease between that co-tenant and the developer is A. Valid and binding on the other co-tenants, B. Valid, provided that the lease does not exceed 70 years. C. Invalid, as one co-tenant cannot obligate the other co-tenants for a lease of the whole property without their consent. D. Invalid, and not binding on the other co-tenants since land owned by co-tenants cannot be leased under any circumstances. Correct answer is C. Invalid, as one co-tenant cannot obligate the other co-tenants for a lease of the whole property without their consent. While one tenant in common with an interest in real property could enter into a valid lease involving just her share, that co-tenant could not obligate the other co-tenants for the whole property without their approval. Question 138. Roof types include the following, except A. Gambrel, B. Mansard, C. Tudor, D. Gable. Correct answer is C. Tudor. Gambrel roof has a distinctive double slope on each side, with a steeper lower slope and a gentler upper slope. Mansard is a four-sided gambrel roof with a distinctive concave curve near the top. Gable is the most common roof type, with a triangular shape formed by two sloping sides that meet at a ridge. Tudor is not a specific roof type, but a rather architectural style that often incorporates a variety of roof shapes, including gables, hips, and shed roofs. Therefore, Tudor doesn't denote a single roof style, but encompasses various roof types within the broader architectural aesthetic. Question 139. A broker must retain copies of his real estate accounts and records prepared or obtained by her, including listings and deposit slips, for a minimum of A. 1 year, B. 3 years, C. 5 years, D. for the duration of his brokerage career. Correct answer is B. 3 years. The Business and Professions Code Section 10148A states that a broker must retain such records for 3 years and have them made available for inspection by the Real Estate Commissioner upon proper notice. Question 140. Wood frame houses. The material that is most commonly used for home construction in California are most susceptible to damage by A. Wind, B. Rain, C. Termites, D. Coyotes. Correct answer is C. Termites. Termites cause billions of dollars in damage to homes every year. In California, home lenders require pest control inspections primarily looking for termites. In some termite-prone areas of the state, pest control inspection is required by the FHA and VA. Question 141. Those parties judged to be incompetent and so without the capacity to contract include A. The insane, B. Minors, C. Those with guardians appointed by the courts, D. All of the above. Correct answer is D. All of the above. Someone who is senile or intoxicated at the time of signing a contract would also be considered legally incompetent. Question 142. What happens to the agency relationship created by a broker accepting a listing if the broker dies? A. The listing remains effective. B. A new broker chosen by the broker's agency will assume the listing and the agency. C. Both A and B. D. The agency immediately terminates. Correct answer is D. The agency immediately terminates. A listing agreement is considered a personal services contract, since a broker agrees to provide services for a seller. Since an agency is a contract for personal services, death or incapacity of the client or broker terminates the agency relationship. Question 143. An agreement that creates a leasehold estate, which ends more than a year after the date of the agreement must be A. Recorded, B. In writing, C. Arranged by an attorney, D. Valued at more than $1,000. Correct answer is B. In writing. Even if the term of a lease is less than a year, the agreement must be writing if the lease will terminate more than a year from the agreement date. Note that only the landlord is required to sign the lease. The tenant can agree to its terms simply by taking occupancy. Question 144. A broker becomes aware that his listed property has large structural damage due to an earthquake that occurred 4 years ago. While showing the property to a prospective purchaser, the broker A. must tell the buyer because the broker has a duty to disclose all material facts. B. does not have to tell the buyer because his duty to disclose does not extend to the buyer. C. does not have to tell the buyer because the house is being sold, as is. D. does have to tell the buyer about the earthquake if the buyer is not aware of it, but not about the damage. Correct answer is A. Must tell the buyer because the broker has a duty to disclose all material facts. A real estate licensee must reveal all material facts, defined as something that would influence a party's purchasing decision. such as massive structural damage, or any other defect of which the licensee is aware, but would not be apparent to a reasonably prudent person. Question 145. Which of the following would most likely appear as a credit in the seller's settlement statement? A. Prepaid taxes for the property. B. Tax lien on the property. C. Unpaid taxes on the property. D. Loan balance on the property. Correct answer is A. Prepaid taxes for the property. Such credits reimburse the seller for items the seller has already paid, which cover time periods during which the seller will not own the property. Question 146. A title insurance company can insure the following. A. Lack of capacity to transfer title. B. Defective delivery of title. C. Whether the tenant's lease interest is free from encumbrances. D. All of the above. Correct answer is D. All of the above. Other potential problems areas regarding a title, such as the validity of an easement, forgery, and impersonation, are also covered under an extended title insurance policy. Question 147. The horizontal piece supporting wall studs, to which the studs are nailed, is termed the A. Floor joist. B. Sole plate. C. Subflooring. D. Crossbar. Correct answer is B. Sole plate. Sole plate is the most accurate term for the horizontal piece of lumber at the bottom of a wall frame, where the wall studs are nailed or attached. It serves as the foundation for the wall structure, distributing the weight of the wall to the underlying support system, foundation or floor joist. Question 148. The rectangular survey system is also called the A. U.S. government survey. B. Meets and bounds. C. U.S. section and township system. D. Both A and C. Correct answer is D. Both A and C. The rectangular survey system provides for a unit of land approximately 24 miles square, bounded by baselines running east and west, and meridians running north and south. This 24 miles square is divided into areas 6 miles square called townships, which are further divided into 36 sections, each 1 mile square. Question 149. Sophie, a college student looking to buy her first car, contracts with Danny to purchase his 1998 Yugo for $3,000. Upon walking to where the car is parked to transfer ownership, they see that the car has been completely vandalized. Its body dented, windshield smashed, wheels slashed. Sophie extends her sympathies to Danny, but tells him, under the circumstances, she will not be completing the transaction to buy the car. If Danny sues Sophie for not honoring their agreement, Sophie will probably A. Win, because both Sophie and Danny were mistaken regarding the damage done to the car. B. Lose, because Danny is not at fault that his car was damaged. C. Win, because it is Danny's fault that his car was damaged. D. Lose, because if Sophie had done a final check of the car before agreeing to buy it, she would have discovered the damage done by vandalism. Correct answer is A. Win, because both Sophie and Danny were mistaken regarding the damage done to the car. An example of mutual mistake: when both parties make a mutual mistaken assumption regarding conditions surrounding a contract, so the contract becomes voidable by the party harmed by the mistake, Sophie, as long as that party did not assume the risk that the assumption was wrong. Both parties thought the car was undamaged, with Sophie never assuming the risk that it was not. She can void the contract if she chooses, with no recourse by Danny. Question 150. When advertising a listed property for sale, a broker is prohibited from A. Creating the false impression that the broker is the property owner. B. Providing the property's listed price in the ad. C. Not providing the exact street address. D. Not providing the amount of financing needed to acquire the property. Correct answer is A. Creating the false impression that the broker is the property owner. A broker who runs an ad implying that the property being sold is his own, rather than a listing he has secured from an owner, is guilty of illegal misrepresentation.